Hi, I'm Paul Mallis, partner in the law firm of Young, Marr, Mallis and Associates. Welcome to the Paul Squared podcast. I started my career in the district attorney's office, and in 2016, I turned my focus to exclusively defending clients charged with crimes. I created this podcast to provide an overview of the criminal law process and to answer the questions I most often get when I first meet prospective clients. My goal is to protect my clients' rights and to guide them through the stressful process of being charged with a crime. While this podcast serves to provide general guidelines around the practice areas we discuss, you should always consult directly with an attorney to make sure the specifics of your particular situation match up with the applicable laws. The decision of choosing an attorney is an important one, and you should give it careful thought before deciding. If you need representation or just have questions, please don't hesitate to contact me at 215-639-5297, or you can visit our law firm's website at www.ykacrim.com. That's ykacrim.com.
This is an introduction to the criminal process. Paul, welcome back.
Thanks for having me back.
Absolutely. So again, in this episode, or the next two episodes, we want to talk about the criminal process overall. I'm sure as clients come to you as a criminal defense attorney, one of their main concerns are what's going to happen. They don't understand the process. They don't understand they've been arrested or charges have been filed against them. There's a multitude of ways that they may be finding that they're facing the criminal justice system, and they want to know what's going to happen next. And I would guess, and you can confirm or correct me on this, that the unknowns out there, or not knowing how this all works, is probably one of the scariest things and the biggest concerns of somebody when they come to you. Is that accurate to say?
Totally, 100%. It's a very foreign environment. It's a foreign language. It's a foreign process, and so it's important that the client understands what that process is, what they're getting themselves in, what they're getting into. So, yeah.
And just to expand off a comment you made there, because I think it is interesting that the whole legal system uses its complete own language, and there's it's a lot of it's based in Latin, and they use terminology that if you're a lawyer, you go to law school, you hear this all the time. You understand what it means. It's a concept that they've boiled down into words, but it's a foreign language, and it has to make people very wary.
It is. And we'll get into it, but I try to draw upon examples when I do these things. I'm representing a middle-aged woman right now. It's a low-level kid. I always say, look, in your world, Mrs. Client, most serious thing ever. I get that it's going to be treated as such. In my world, though, this is very straightforward. And in this particular case, it is a very straightforward matter. But I'm really taking the time with this client because she really is. She's a nice lady. I'm really taking the time to really explain each and every step of the process. She's very detail oriented. So I'm being patient with her. And I know that she appreciates that. So in short, the process, the client's understanding of the process is a very important part of my own process. And so, yeah, just felt that was worth mentioning.
Yeah. And it's taking some of the mystery away from it. And it's like in anything that, I think the best doctors that are out there explain to you what's going on with the process. It's not just to say, here's your treatment plan. Right. Because sure, some people, maybe that's all they want to know. Jay, I trust you. I just want the treatment plan. But I think most people want to know, like, why am I having the issues that I'm having? So there's an understanding there. Right. And I think law is no different in that fashion. So if we talk about, can we start with the basic explanation of the legal process? So or criminal process. So, someone's been arrested. We'll use that as our example. And I guess, if we're using this as the jumping off point, are there other ways people can become aware that they've got a criminal issue in front of them other than just being arrested?
Yeah, I think the best way to explain this is there's really, in Pennsylvania, there's two different ways one could be arrested. Obviously, in the most literal sense, handcuffs and taken into custody. But you can also be arrested by receiving a summons. It's an arrest by summons where you receive by certified mail and regular mail from the district court notice that you've been arrested. A criminal action's been filed against you. So depending on whether or not it's where you've been arrested in the traditional sense or you've received a summons, that answers the question of what the process is. So let's talk about like an arrest warrant in the traditional sense. Sometimes somebody can be taken into custody and they're going to see a judge like that night, right? Other times somebody can be taken into custody and they're detained, but they're not actually arrested, and so they'll be released. And then at some point later in time, an arrest warrant will be issued. And usually the investigating detective or officer will reach out to that person and say, look, you've got an arrest warrant, you have to turn yourself in. Just depends on the type of crime. But when there's an arrest warrant, or when you've been arrested right there on the spot, you're going to go through what's called a preliminary arraignment, which is a bail hearing. That's really where a judge, a magistrate, district court justice, we call them, he or she is going to read to you the charges. You're going to enter an official plea of not guilty to those charges, and then a bail hearing is going to occur. Anytime somebody's been arrested in Pennsylvania, a judge has to set bail in the case, and that occurs during this preliminary arraignment process. And bail's based on two things. It's based on, are you a flight risk? Are you going to appear at all of your court appearances? And or are you a danger to the community, right? Do we need to keep you incarcerated to protect the community? So depending on the answers to those questions, those factors, bail will be set either at what's called an unsecured amount, meaning that you do not need to post money. It's unsecured. You'll be released, or a secured amount where you need to post a certain percentage or the entirety of that secured amount of money in order to be released. And if you don't, then you're remanded back to the local county prison until you could post the bail or until the matter is finally concluded. So that's kind of how the preliminary arraignment process works. The bail process works if there is an arrest warrant or you're arrested on the spot. Now,
so if I can ask you a question, so
yeah, please.
kind of giving some examples to those two scenarios. Someone arrested on the spot, maybe a good example would be a DUI. Is that a fair, like you get pulled over, they take a breathalyzer or you refuse it and they take you and arrest you?
Yes, but you're going to, in a DUI type situation, you're going to be released. So technically you're detained. It's not really an arrest. In that situation, you're going to receive a summons to appear in court. And we call that summons the equivalent of an arrest. And that summons you'll get at a point later in time. You'll be released that night, and then you'll receive the summons by mail. So,
so what would be an example? Well, what would be a good example of someone being arrested? What's the, I know all charges are different, but could you just give us sort of a practical, I typically see this?
Car stop, drugs or a gun inside of the car.
Okay.
You're the driver, you're the passenger.
You're not
getting released.
Okay.
Yeah.
So
you're not getting released.
Okay. Yeah. So you're going to go to jail. So a DUI might be you're detained where you're in custody, but they haven't arrested you. They're going to let you go. Again, unless there are other circumstances surrounding it, they're going to let you go. And that's where you're going to get that paper in the mail that says, all right, you're being charged with this. You're going to have to defend yourself, and you could be arrested at a later point.
Yeah. You're being charged with this. You're going to receive a summons by mail. You're going to have to attend what's called a preliminary hearing. And that preliminary arraignment process, that bail process, will happen simultaneously to your preliminary hearing. Okay. So, and in those types of situations, realistically, we're looking at an unsecured bail. You'll be released on your own assurance that you'll be appearing in all of your court appearances. It's a low-level type offense. Yeah.
And then there are other situations where maybe you weren't detained at all, but you get a summons in the mail that says, hey, something happened and the police did whatever investigation they're going to investigate. And they're saying, we're bringing charges against you. And that any one of those three kicks off the next stage, which is the preliminary hearing, the bail hearing, and determining whether you should be detained or not detained with or without money.
Exactly.
Okay.
Exactly. It's that's the process. Yep.
Okay. I'm sorry. And so I interrupted you, but I want to just make sure it was clear, like that's the stages and examples of when that happens. So we've gotten past the preliminary hearing, the bail hearing. What's next? What typically is the next stages?
Well, I think we got to go back actually. So the preliminary hearing is a really important step in the criminal process, if you will. So we've gotten past the arraignment, the preliminary arraignment. We've gotten past the bail hearing. You're either sitting on a secure bail or you're unsecured bail and you're not sitting. And then we have a preliminary hearing. Very, very important. I always tell clients, obviously I want the client to go with me. Whether or not you retain me as your lawyer or you retain somebody else, very important to have a lawyer at this process. It's the preliminary hearing is kind of a, does the government have enough to pass the smell test type hearing? It's an evidence hearing. It's not a guilt or innocent hearing. It's not beyond a reasonable doubt. It's not sentencing. It's just, is there enough to pass the smell test? And if there is not, then the case gets dismissed. If there is, then the case moves forward. So that's a really, really important step in the process. And ordinarily, what we see at that process is there's an evidentiary hearing where the government puts on its case, its summary of the case, its summary of the witnesses, and then we, as the defense attorney, we cross-examine those witnesses, and then we make legal argument on the evidence that's been presented and whether or not the case should move forward or be dismissed. So that's a really, really important step in the process.
So you don't want to skip the preliminary. At least you don't want to make light of the preliminary hearing, because you have a chance that your case could get dismissed there, and B, I'm assuming this is your opportunity to see what is it the other side is going to bring against you to understand, what you're going to have to defend yourself against.
Right. You're building your theory of the case. And so you're going to see the strengths and weaknesses that the government has at the preliminary hearing. So from a kind of a QB vision type scenario where you see the entirety of the case. So yeah, that's an important step of the process. Can't be overlooked.
Okay. So we had the bail, the arraignment hearing, the bail hearing, the preliminary hearing. Is that the correct order of how these typically flow? Okay. And then what's next?
So, well, obviously, if there's not enough evidence at the preliminary hearing, case is dismissed, then there is no next. But if enough evidence has been presented, then the case moves forward to the court of common pleas level, the trial court level, we call it, where the case is advancing to what's called a formal arraignment, right? Not the preliminary arraignment, but a formal arraignment where you're now read the actual charges on a document called the Bill of Information. And again, you maintain a plea of not guilty. And then the case advances to, it varies from county to county, the name of the next step of the process. But really, it's a status hearing. Judge is going to want to status the case to see which direction it's going to go. It's going to be a trial. It's going to be a non-trial type disposition. And it's kind of at that stage where the lawyers on both sides, the prosecutor and the defense attorney, start talking. We're exchanging what's called discovery, which is all of the evidence that the prosecutor has to prove their case, all the evidence that the defense attorney has to defend his or her case. So we're going through that discovery process. We're filing motions, maybe a motion to suppress. Maybe there was a statement that was obtained unlawfully. Maybe there was a search that was done unlawfully. And we're talking about, is there a resolution, a plea deal that could be reached? And so that's kind of what a status hearing is. And maybe a second status hearing has to be scheduled in order to resolve all those issues. Maybe a third or a fourth status hearing needs to be resolved. And so the process, the roadmap, if you will, from the time of arrest to you get to that second or third status hearing, that could be 6 months of time. So, that's kind of you're funneling it down toward a disposition of the case. And yeah.
And you mentioned in that stages after the preliminary hearing where you're going through discovering, having these status conferences, that's where you're typically talking plea deals. Do they ever happen at the preliminary hearing? Or I mean, I guess if your case is dismissed, it's dismissed. There is no plea to discuss. Or do you typically see all that sort of negotiation happening after the preliminary hearing?
No, no, definitely. So there's oftentimes negotiations that occur at the preliminary hearing. For example, let's say that client is charged with, four different offenses. Sometimes what a prosecutor will do is say, I'm going to withdraw two of those four offenses if your client agrees to waive his or her right to a preliminary hearing. That doesn't mean that the client's pleading guilty. Waiving their right means they're waiving their right to cross-examine the witnesses, to challenge the evidence, and to make legal argument. They're waiving those rights in exchange for the prosecution's offer to negotiate some of the charges. So in short, negotiations oftentimes do also occur at the preliminary hearing stage.
And I would imagine that's the legal balancing where advice from a lawyer telling you, look, you should consider this or not consider this because the most serious charges are getting dropped out of here, and don't worry,
Right.
we're not giving up our ability to fight it. We're just saying that it's going to continue to advance just on these two charges. That's where
Right.
you bring value.
I always say to a client at the preliminary hearing stage, if I could put that client in a better position than the one that they're in before the preliminary hearing, then we're going to do that. So
Right.
if a prosecutor is telling me we're going to reduce the charges, then obviously waiving the preliminary hearing is going to put him or her in a better position. So
Right.
that's, yes, it's very important that you have counsel at that stage to advise you, well, what's going to put me in a better position.
Right. Unless you think, hey, this is a no-brainer. There's not enough evidence here to keep the charges going. But I mean, how often do you come across that where there's very little or to no evidence? You think you're just going to completely win it at the preliminary hearing?
Got a case on Monday coming up, a vehicular homicide case that I don't know if we're going to accept any offer because I have a very good defense. We have a very good defense in that case. So any negotiation that is discussed, I don't know. We're going to have a decision to make. It's going to be a game time call. So
So it does
some,
happen.
so it does happen. It's rare, but it does happen. If we've got a good case and we've got a chance of getting it thrown out at the prelim, why advance it? Sometimes client wants to take that risk, and sometimes I want to advise the client to take that risk. It does happen.
And so if we're recapping all the steps again, and I'm repeating
Yeah.
myself here, but it just to make sure that the listeners are getting this. So we have the arrest that can come in charges that can come in a multitude of ways. It can be from an actual arrest. It can be a detainment where arrest comes later through paperwork. It could just be, paperwork that comes through to say, hey, charges are being filed against you. That's the first notice that the person has that, hey, I'm going to be having to defend myself against criminal charges. Then we have the arraignment hearing and the bail hearings, which are basically saying, is there enough information here to continue this forward? And if so, does this person need to be in jail, or can they be released? Can they be released on their own recognizance, which means no money, or do they have to put some money down? And if so, how much? Then we have a preliminary hearing, which is the evidentiary hearing that you just described, where you get the chance to argue the sufficiency or the reasonableness of the evidence that the police have. You get to get a preview of their case and see what they're going to bring against you. A judge could decide there's not enough evidence at that point and dismiss the case. You could be playing ball here and a little bit of poker of dropping charges and in favor of waiving certain things and moving it forward. If it advances to the next stage, you're now at status conferences, and you're in kind of a longer section of the case where you could be discussing, is there a plea agreement or something to happen here, or you're advancing the ball towards trial, and you can have a trial in front of a judge or a trial in front of a jury. And so you have a trial, and your trial either finds guilt or innocence. what happens? Is there anything? Is that it, or are there any things that can happen after a trial? Is that
Yeah, after verdict is reached at trial, let's say it's a guilty verdict, the client has what we call appellate rights, appeal rights, and we call them post-sentence motions. So let's let's say that the client goes to trial, gets a bad outcome, gets a guilty verdict. They're going to go through sentencing phase. Judge is going to find out what the punishment is. So sentencing is going to occur. After that sentencing, you have appeal rights that kick in. They come to fruition, and there are what's called post sentence motions that could be filed, and they have to be done timely and they have to be done in writing. They're very, very strict. You can file post sentence motions pretty much for anything. You can file a post sentence motion asking the court to reconsider the sentence. So you get a harsh sentence, you don't like it, you could file a motion to reconsider the sentence. You could file a post sentence motion to challenge the verdict that was rendered after trial. You could file post sentence motion arguing that a ruling that was made by the trial court judge was incorrect. You could file post sentence motions for various different issues that came up during the trial process. What's important is that post sentence motion is filed timely, and so the law says that you have 10 days from the date that the sentence is imposed to file a post sentence motion with the trial court judge, the judge that imposed the sentence. You have 30 days from the date that the sentence was imposed to bypass that trial judge and just file your appeal with the Pennsylvania Superior Court, which is like the Court of Appeals, the next higher court. So, so you could, it just the important part is that those motions are done timely and in writing.
so you can't
That's
sit
the
on it
next step.
if you're going to appeal? That's something that you need to do pretty quickly.
Right. And as the trial court counsel has a duty to file those motions if the client wishes to file them. So if you're retained if you're retained as counsel at the appellate level or not, you still have that duty to file the motion to preserve the client's rights on appeal. Otherwise, you could be deemed ineffective as counsel. You can have disciplinary issues with the board. So that's an important piece to it as well.
And you mentioned in your description of some of the motions that can be filed, you could appeal the sentencing. So is the sentencing a separate step from the actual trial that determines guilt?
Yeah. And sentencing is a step in the process, whether or not you go through trial or plead guilty.
Okay.
Let's say that, you don't want to go to trial, you get a good plea deal, right? Where certain charges are going to be withdrawn, but there's no agreement as to sentence. Let's say that. We call that an open guilty plea, where the sentence is to be determined by the court. Or let's say that you go through trial, you lose, and then you go through sentencing. A judge is going to impose sentence and fashion a sentence by looking to what's called sentencing guidelines. And guidelines are based on somebody's prior record, what their prior criminal history looks like, and the nature of the offense that was committed. We call it an offense gravity score. So it's kind of like an algorithm. The guidelines look to your prior record score and your offense gravity score, and then it spits out to you a standard range sentence based on those two things. And it spits out an aggravated range sentence and a mitigated range sentence. So sentencing judge has full discretion in imposing a sentence, but those are guidelines that a judge will look to. So, of course, if the client doesn't like that sentence, they can file a motion to ask them to reconsider it.
Right. And do you see most plea deals or many plea deals leaving the sentencing up to the judge at that point, or is the sentencing, and does the judge have to accept the plea deal that might be negotiated?
So if there's a negotiated plea deal, meaning that the sentence is negotiated, the judge needs to accept that. The judge rejects it, which I have seen happen. It happens. It doesn't happen often, but it happens. It doesn't happen rarely. I have seen it happen. Maybe the judge thinks that the deal is inappropriate given the facts of the case. Judge can reject it. You can then withdraw your guilty plea, and then the case will be marked. It'll be listed for trial, or the parties will go back and renegotiate a deal that's more appropriate. I've seen that too. So the judge does have the ability to reject the plea deal. So it's really important that when you are negotiating a deal, prosecutor gives you the deal of a lifetime. You take it to your client. You also got to be mindful, like, is this deal going to be accepted by this particular judge?
Right. And so that's where understanding who's who, personalities, the history, all those kind of things really come into play of saying, are you in front of somebody who tends to sentence on a harsher side on certain things, or look at certain areas harder than others? That's all important information to go into the equation of helping to make the right decisions.
Absolutely. And it's really important too, when you're deciding whether or not to go to trial, or you're deciding to do what's called an open plea and leave the sentence up to the judge. You need to know that judge and the judge's personality when making that decision. It's very, very important.
Got it. Well, Paul, I think that's a good description of the overall process of being charged with a crime and the steps that walk through it. What's going to happen next, and from that person's perspective, what they should or shouldn't be doing in terms of saying or doing things with the police officer. So we'll get into some of the nitty gritty in that on the next episode. So we'll finish up our introduction to the criminal process, where again, we'll be talking more about the specifics of an arrest and what you should or shouldn't be doing at the time of an arrest. So